Good evening. How's everybody doing? Great to be learning with you on a Wednesday. Yom Revi'i. Let's light up the darkness. New wisdom candle. Who's in the house? Yehud in South Carolina, Bilam in Missouri, Stephen in New Hampshire, Yosef in Englewood, New Jersey, Joe in the Inland Empire, Karen in Northern California, Lorraine in Texas, Sharon, wait for it, in Las Vegas. Hope you're having a good time there. Melissa in Great Neck, Bell in Texas, Shandora in the Bronx. Chaim in Florida, Marjorie in Georgia, Ella in Southern California. Okay, let's get into it. We're so close with God's help. Tomorrow, we'll make a siyum on Tractate Bava Basra, the longest, largest volume in the Talmud. Our daf today is page 174 here in Bava Basra, chapter 10, continuing our discussion of Mishnah number 9. We picked this up right near the top of page 174a. We were talking about the difference between a standard guarantor and an unconditional guarantor, which basically seems to mean that if I lend you money, okay, and maybe I don't want to lend you money, or as I say, you lend me money, and maybe you don't really want to lend me money because you're not sure if I'm going to pay it back, but Johnny over here says, I'll guarantee Sal's loan. So if he doesn't pay you back, I'll pay you back. That's normally how we understand it. And yesterday we saw that when the time comes to get paid back, you can't just go to Johnny. You have to come to me first. But if I have no assets, I can't pay you, then you can go to Johnny. That seems like a standard guarantor. And the unconditional guarantor seemed to be that you don't even have to come to me first. You can go straight to Johnny because it was an unconditional guarantee. But as we saw, not everybody agreed with that. Maybe it's only an unconditional guarantee if I don't have assets, but if I do have assets, you have to come to me first. So let's read more about this. So the Gemara discusses which expressions confer upon a person the status of a standard guarantor, and which terms confer the status of an unconditional guarantor. So Rav Huna says that if one says to a potential creditor, lend money to him and I am a guarantor, or lend money to him and I will repay the debt, or lend money to him and I am obligated to repay the debt, or lend money to him and I will give the money back to you. All of these expressions confer the status of a standard guarantee. You would have to come to me first before going to Johnny if he used any of those expressions to create the guarantor relationship. Now, if one says, give money to him, and I am an unconditional guarantor. Well, now, that sounds like Johnny is willing to be an unconditional guarantor, and you could go to him first. Sounds like, give money to him, and I will repay the debt. Or give money to him, and I am obligated to repay the debt. Or give money to him, and I will give the money back to you. All these expressions confer the status on, let's say, Johnny, for example, of an unconditional guarantor. This would be the language of unconditional guarantee. And it seems like the usage of the word give to the borrower, as opposed to the language of lend to the borrower, confers the status of unconditional guarantor. It would seem that way where we are right now in our discussion, but we would be mistaken if that is what we thought. Let's see why. A dilemma was raised before the sages. What is the law if one says, lend money to him, and I am an unconditional guarantor? Right? That sounds like I'm going to be an unconditional guarantor. On the one hand, the word lend is used, and lend seems to be associated with standard guarantee, not unconditional. But on the other hand, this guarantor explicitly states that he will be an unconditional guarantor. And what is the law if someone says, give money to him, and I am a guarantor? Now he's using the word give, which seems to be associated with the unconditional guarantee, but he's not calling himself an unconditional guarantor. He's just calling himself a guarantor. So, resolving these two questions, Rabbi Yitzchak says, when one employs the language of a standard guarantee, it is a standard guarantee, even if he also used the word give. And when one employs the language of an unconditional guarantee, it is an unconditional guarantee. Well, Rabbi Yitzchak sounds sensible, clear. Is that the law? No. Rav Chisda says, all the expressions mentioned so far in this discussion are expressions of an unconditional guarantee, except for lend money to him and I am a guarantor. That's the weakest of the formulations. That would be a standard guarantee. All the other ones are unconditional guarantor, the strongest possible relationship from the perspective of the lender, because he knows he's got two people he can look to get paid, and that the guarantor is an absolute guarantee. He doesn't even have to go to the borrower first. He could go right to the guarantor, who presumably is a person with a lot of money, and that's why he's being asked to be a guarantor. So you might think that that's the law, but you'd be wrong again. Rava says, all of the expressions mentioned in the discussion are expressions of a standard guarantee. Even give money to him and I will be an unconditional guarantor. Even that expression only creates standard guarantee. The only expression that creates an unconditional guarantee, according to Rava, give money to him and I will give the money back to you. Give and give. Only that formula creates the relationship of an unconditional guarantor, and that is the halacha. That is where the law ended up. Mar Bar Amemar said to Rav Ashi, my father said the following: if one says, give money to him and I will give the money back to you, this expression binds the guarantor to such an extent that the lender has no claim against the borrower at all. His only option is to collect the debt from the guarantor. That's how strong the language is. But the Gemara rejects this last statement, but that is not so. Rather, the debtor is not exempted from dealing with the creditor unless the guarantor takes the money from the creditor and gives it to the debtor with his own hand. In other words, the guarantor wasn't a guarantor at all. He borrowed the money from the lender, and then he lent the money to the borrower. So then, yeah, of course, the only one with a relationship with the lender is this guy who's not a guarantor. He's actually the first borrower, and then he lends to someone else. But in every other case, it's only a standard guarantee unless the guarantor said, give the money to him and I will give the money to you. That is the unconditional guarantee language. Now, let's hear some incidents. The Gemara relates there was once a certain judge who permitted a creditor to enter the debtor's property and collect it for his debt before lodging a claim against the debtor himself. He hadn't been paid back. He didn't even go to the debtor and say, hey, you owe me money. He just walked over to some property that the debtor owned and took the property. Rav Chanan, the son of Rav Yeva, overruled that judge and expelled the creditor from the property that he had seized. And when Rav heard about this, he said, who is wise enough to perform such a matter, i.e. issue this ruling, if not Rav Chanan, the son of Rav Yeva? He holds that a person's property is a guarantee for him, i.e. a person's property acts as a guarantor for the loan if the debtor does not repay it. It's like your property acts as a guarantor. That's why your property is considered collateral, right? So if you don't pay back the loan, that person will take your property. But what do we learn about a guarantor? You can only go to the guarantor after you've first gone to the borrower as a creditor. You went to the borrower and said, pay me back the money you owe me. And then if he doesn't pay, that's when you can go to the guarantor. Likewise, if you're going to seize a person's property, and legally speaking, a person's property acts as his guarantor, so first you have to go to the borrower, ask him to pay you back, and if he doesn't pay you back, then you can seize the property. One who lends money to another with the assurance of a guarantor cannot collect the debt from the guarantor. And we established that the Mishna means that he cannot collect the debt from the guarantor at the outset before seeking payment from the debtor himself. And so too, he cannot collect the debt by taking the debtor's property without first seeking payment from the debtor himself. Now, another incident. The Gemara relates there was once a certain guarantor for orphans whose father borrowed money and then he died. And the orphans were minors, and this guarantor repaid the debt to the creditor before informing the orphans that he was repaying the debt for them. And the guarantor now sought reimbursement from the orphans. This is a high-minded person, right? Probably. There's a possibility that there's some fraud going on here, but most likely somebody felt bad, right, for the orphans who lost their father. And who had borrowed money before he died. So this guy acts as the guarantor, and he says, you know what? I mean, he was a guarantor, right? So he was already involved. He saw that the original borrower had died. He knew that he was the guarantor, so he just went and paid the loan. Now he goes to the estate, basically, which belongs to the orphans, and he says, I want to be reimbursed for paying back this loan of the father, that he borrowed before he died. And so I want to be made whole from the estate that belongs to these orphans. Sounds reasonable. Rav Papa said, repaying a creditor, right, paying back a loan, this is a mitzvah. And orphans who are minors are not obligated in performing a mitzvah. Orphans who are minors, right? They're not of age yet. They haven't become an adult. They haven't had their bar mitzvah. So they're not obligated in mitzvahs. They therefore do not have to repay any debts owed by their deceased father until they reach the age of majority. Now, there's going to be two different reasons given why they don't have to pay their father's debts until they become adults. And then depending on which reason we look to, we would have different outcomes in different situations. And Rav Huna, the son of Rav Yehoshua, also said that the orphans do not have to pay the guarantor until reaching majority, but for a different reason. The first reason was they're not obligated in mitzvahs, so they don't have to pay until they become obligated in mitzvahs when they become adults. That's the first reason. Now, the second reason is given by Rav Huna, the son of Rav Yehoshua, who said that orphans do not have to repay the guarantor until reaching majority because, say that perhaps the deceased, right, the father before he died, gave bundles of money to his creditor before his death. and therefore some or all of the debt has already been paid. As long as they are minors, the heirs would not be aware of this payment that their father may have made. But upon reaching majority, there is a chance that they may examine their father's papers and discover that their father had in fact paid money to this creditor. Therefore, the payment is deferred until they reach majority. 174b. The Gemara asks, what is the difference between the opinion of Rav Papa and that of Rav Huna, the son of Rav Yehoshua? As both agree that the orphans are exempt from paying the debt until they become adults, until they reach majority. So the Gemara answers, the difference between them is in a case where the one who owed the money, i.e. the deceased, their father, admits explicitly just before his death that he did not yet repay any of his loan. Alternatively, there is a difference between them in a case where the court excommunicated the father for not cooperating with the court in repaying his debt, and he died while still in a state of excommunication, which demonstrates that the debt had not been repaid prior to his death. In both of these cases, Rav Papa would exempt the minor orphans from payment because minors are not obligated to perform mitzvahs. But Rav Huna, the son of Rav Yehoshua, would require them to repay the debt immediately, as there is no possibility that their father had already repaid his debt before he died. Now, the sages of Eretz Yisrael sent a ruling from there to the Jewish community in Babylonia, in a case where the court had excommunicated a debtor for not cooperating and repaying his debt, and the debtor died while still in a state of excommunication. The law is in accordance with the opinion of Rav Huna, the son of Rav Yehoshua, and the orphans must repay the debt immediately. So it's not a question of there's no repayment of money owed by the father until they become adults. It seems like the rationale is they don't have to repay until they become adults, because only when they become adults is there even a chance that they would examine their father's papers and records and learn exactly where he stood, what he owed and what he didn't. Now, the Gemara raises an objection from a Baraisa. A guarantor for a debt who has the promissory note for that debt in his possession, indicating that he has repaid the debt, and now seeks reimbursement from the debtor. Right? So the guarantor paid off the debt on behalf of the lender. Once the debt was paid off, the lender gives the promissory note. In this case, the borrower didn't repay the debt, the guarantor did. So when the guarantor repays the loan, he receives the promissory note that was evidence of the original loan between the lender and the borrower. Now the guarantor has the promissory note. And now he seeks reimbursement from the debtor. He cannot collect if the debtor has died and the obligation for the debt has fallen to his heirs, who are still minor children. But if it is written by the creditor in the promissory note, I received repayment from you, the guarantor, then the guarantor can collect the debt from the minor heirs. Now, based on this Baraisa, we go back to the case we were discussing before. So granted, according to the opinion of Rav Huna, the son of Rav Yehoshua, you find a case where the minor heirs would be required to repay the debt, such as when the one who owed the money, i.e. their father, the deceased, admitted explicitly just before his death that he had not yet repaid the loan. But according to the opinion of Rav Papa, who maintains that minor heirs never have to repay their father's debts, then we have a difficulty. What is the case discussed in this Baraisa? And the Gemara answers, it is different there, as it is for this reason that the creditor troubled himself and wrote for the guarantor that I received payment from you. Meaning, once the creditor writes this in the promissory note, it attains the status of a promissory note of the guarantor held directly against the debtor. And even Rav Papa agrees that a debt that is recorded in a promissory note can be collected from the deceased's property immediately, even from minor heirs. Somebody who's holding a promissory note from a man who died can go and collect from the estate. And because he has the promissory note, he's not going to have to wait until the minors, grow up. He's not going to have to wait that long. He can present it now that there is an estate. Now, the Gemara relates, there was a certain guarantor who had guaranteed a loan given by a Gentile, who repaid the Gentile creditor before the Gentile creditor claimed repayment from the orphans who survived the original borrower, the father. The guarantor now sought reimbursement from the orphans. Rav Mordecai said to Rav Ashi, this is what Avimi of Hagronia said in the name of Rava. Even according to the one who says that we are concerned for the possibility that the deceased may have given bundles of money to the creditor before his death, this statement applies only in the case of a Jewish creditor. But in the case of a Gentile creditor, since according to Gentile law, and this seems to be the way it was in Bavel, which is part of the Persian Empire, the creditor is entitled to go directly to a guarantor. Okay, so that's quite different. We've already learned that a creditor, a lender, cannot go to the guarantor right away, except maybe in the case of an unconditional guarantee, but certainly in the case of a normal guarantee, he has to go to the borrower first, and if the borrower doesn't pay back, then he can go to the guarantor. But according to Gentile law in this time and place, the lender, when it's time to get paid back, he can go straight to the guarantor. He doesn't have to talk to the borrower at all. And that's a real difference between this Gentile law and Jewish law in that time and place. And that discrepancy will create a different situation if we have a Gentile lender or a Jewish lender. So let's see what happens. But in the case of a Gentile creditor, since according to Gentile law, he's entitled to go directly to the guarantor, we are not concerned for the possibility that the father, before he died, may have given bundles of money. The father would not repay the Gentile before the loan is due, as the Gentile has the right to collect directly from the guarantor, and he would thereby receive double payment. So if you're borrowing from a Gentile in that place, and the Gentile will only lend to you if you have a guarantor, and then when it's time to get repaid, he's going to go to the guarantor. So then why would you ever, when it's time to repay the loan that you borrowed, go and give it to the Gentile? You wouldn't do that. You'd give it to your guarantor so that he's ready to repay when the Gentile comes looking for him. The reason being that if you just repay the Gentile, he might not admit it, and he might just go to the guarantor. Obviously, if he's honest, he's not going to do that. But in so many of these cases, we're concerned where somebody takes advantage of the system and they want to build in safeguards against a person who would take advantage. Now, Rav Ashi said to Rav Mordecai, on the contrary, even according to the one who says that we are not concerned for the possibility that the deceased father, before he died, may have given bundles of money, this statement applies only in the case of a Jewish creditor. But in the case of a Gentile creditor, since according to Gentile law, they are entitled to go directly to a guarantor, no guarantor would accept upon himself the guarantee to guarantee such a loan if the debtor had not given bundles of money as collateral to the Gentile creditor from the outset. Now the Mishna taught, and so Rabban Shimon ben Gamliel would say, if there is a guarantor for a woman for her marriage contract, and her husband is divorcing her, so the husband must now take a vow prohibiting himself from deriving any benefit from her so that he can never remarry her. And the Gemara relates an incident, right? Because what they're worried about is collusion. That, that she is owed money in a marriage contract. So if the marriage ever ends, the husband owes her a bunch of money. And they might have had a big marriage contract. Let's say it's 1,000 dinars. The minimum, right, we saw, I think, was 200 or 400 for a virgin. Or was it 100 and 200 for a virgin? But whatever. But you could also make a bigger one. So let's say it was a big marriage contract, 1,000 dinars. Now they're broke. The couple is broke. They don't know what they're going to do. So what they might say is, well, let's get divorced. I have no money. So my guarantor, he'll have to pay the marriage contract. You'll get the 1,000 dinars. then we'll get remarried and we'll have 1,000 dinars to, kick off our new life and start a business. So to prevent them colluding that way against the person who was nice enough to act as a guarantor at the time they got married, we make the husband in that situation take a vow that he will if he divorces her, he can never benefit from her for the rest of her life. So therefore, if he's a pious person, he can never benefit from her. So it means he can't remarry her. So she'll get paid the 1,000 dinars of the marriage contract, but he won't benefit from that because he can never remarry her. Now, there was an incident. Someone named Moshe Bar Atzari was a guarantor for the marriage contract of his daughter-in-law, right? So his son married a woman, guaranteeing the money promised by his son in the event of a death or divorce, right? So the father is acting as a guarantor for the ketubah payment that his son would owe if he predeceased or divorced his wife. Now, this Moshe Bar Atzari, he had a famous son, the Torah scholar Rav Huna, who at this time was a young Torah scholar and broke, right, in financial straits. Abaye said, meaning Rav Huna was so broke that he was going to have to go get a job rather than spend 18 hours a day learning Torah. And the whole Torah community could tell this is a genius. We need him in the study hall learning Torah. He can't have to go out and work because that would be a waste of his time. So somebody made a suggestion. Abaye said, is there no one who will go advise Rav Huna that he should divorce his wife? And she will go and collect her marriage contract from Rav Huna's father, and then Rav Huna should remarry her. Sounds like Rav Huna's father, for whatever reason, Rav Huna couldn't just go ask his father for the money so that he could keep learning. Maybe, there was not a good relationship there. But the father, at least when he was young, had acted as the guarantor for that ketubah payment. So now they're saying, okay, get divorced, get paid, get the payment of the marriage contract, and then you can remarry. Sounds like collusion against his dad. Rava said to Abaye, but didn't we learn in the Mishnah that when a husband divorces his wife in such circumstances, he must take a vow, prohibiting himself from deriving any benefit from her, thereby precluding the possibility of remarriage? And Abaye said to him, is that to say that everyone who divorces his wife divorces her in a court? Rav Huna could be advised to divorce his wife outside the court, in which case he could do so without being forced to take the prescribed vow. Ultimately, it was revealed that this Rav Huna was a priest who may not marry a divorcee, even his own ex-wife. Abaye's suggestion was therefore not an option for him. And upon hearing this, Abaye said, this is in accordance with the adage that people say, poverty follows the poor. Right? The poor don't have a way out because they just seem to be unlucky, and that's why they're poor. Now, the Gemara asks, but did Abaye really say this? Would he really encourage giving such advice that Rav Huna should collude against his father to get that payment that the father guaranteed for the ketubah payment? But doesn't Abaye himself say, who is a cunning, wicked person? This is one who provides advice to sell property in accordance with the ruling of Rabban Shimon ben Gamliel. As we learned elsewhere in Tractate Kesuvos 95b, if one says, my property is hereby bequeathed to you, and after you die it will pass to so-and-so, Rabban Shimon ben Gamliel rules that the first recipient can sell the property, which would thereby deprive the second recipient from ever receiving it. And Abaye said that giving advice to someone to pursue such action, though it is legally sound, right, it is technically legal, this is considered wicked. And here as well, why would he give advice to Rav Huna to divorce his wife only in order to force his father to pay the marriage contract? And the Gemara answers, when dealing with one's own son, it is different. It is not considered wickedness to force a father to give money to his own son. Moreover, when dealing with a Torah scholar, it is different. It is not considered wickedness to procure money for a Torah scholar because the money enables him to pursue his studies. The Gemara asks another question with regard to this incident, but wasn't Moshe Bar Atzari a guarantor? And we maintain, as the Gemara will soon note, that a guarantor for a marriage contract does not become obligated to pay? And the Gemara answers, he was an unconditional guarantor. Well, the Gemara objects to this. This works out well according to the one who says that an unconditional guarantor for a marriage contract actually is obligated to pay it, even if the husband has no property of his own at the time of the marriage. According to this opinion, all is well. But according to the one who says if the husband has his own property, the unconditional guarantor becomes obligated to pay, but if the husband does not have his own property, he does not become obligated. Then what is there to say? So Rav Huna obviously did not have any property of his own. He was a young Torah scholar. Why then was his father held responsible for paying his marriage contract according to this latter opinion? And the Gemara answers, if you wish, say that Rav Huna had property when he got married, so that his father's guarantee took effect, but it became blighted, i.e. it was ruined or lost in the interim. And if you wish, say instead, a father vis-a-vis his son sincerely obligates himself to guarantee his marriage contract even when the son has no property of his own. Interesting, this idea that according to one view, one ruling, that if the groom has no property, then the guarantor doesn't become obligated to guarantee it, because it would mean that he's saying from the outset, look to me to pay the marriage contract, and he wouldn't say that. He's only saying, I'll be the guarantor because I know that this guy has property. If he doesn't have any property, why would he say he's the guarantor? Rather, he should give the groom property. If he's not going to do that, right, then what we're getting to is an asmachta. The guy never meant it, right? He never thought that he'd have to pay. And if it turns out that the groom never had property, that this guy was on the hook from the beginning, that's obviously something he didn't know about or didn't, look into. And he was just trying to help this couple get married, but he didn't really think he would be on the hook, and therefore he didn't consent to be that kind of a guarantor. Now, the Gemara elaborates. This is as it was stated. Everyone agrees that a standard guarantor for a marriage contract does not become obligated to pay the marriage contract. Right? A standard guarantor for a marriage contract isn't obligated at all. That's what it sounds like. And everyone agrees that an unconditional guarantor for a creditor, i.e. for a loan, becomes obligated to repay the loan. Okay, so the two extremes. Standard guarantor for a marriage contract, no obligation. Unconditional guarantor for a regular loan, obligated. So that everyone agrees on that. Now it's these two middle cases. With regard to an unconditional guarantor for a marriage contract and a standard guarantor for a creditor, right, just a regular loan, here the sages disagree. One sage holds that if the debtor or the husband has his own property, then these guarantors become obligated for the guarantees they have undertaken. But if the borrower or husband does not have property, the guarantor does not become obligated. And the other sage holds that whether the debtor or husband has property or he doesn't have property, the guarantor becomes obligated to pay it. And the halacha is, the law is, that a guarantor becomes obligated to pay, whether the debtor has his own property or whether he does not have his own property. However, this is to the exclusion of a guarantor for a marriage contract, in which case, even if the husband has his own property, the guarantor does not become obligated to pay. And what is the reason for this? The intention of the guarantor is to perform the mitzvah of facilitating a marriage by encouraging the woman to consent to the marriage as a result of his involvement. But he does not truly intend to obligate himself. And furthermore, in contrast to a guarantor for a loan where the creditor stands to suffer a loss if he is not repaid, the woman does not suffer any concrete loss as the husband does not borrow money from the woman. Therefore, the level of commitment of the guarantor in this case is lower. Accordingly, the sages instituted that the guarantor does not become responsible for payment of the marriage contract from his own property. Now, presumably, they could have done something like a statement in court that this guarantor understands that he is undertaking to guarantee that marriage contract, while knowing that the man has property or doesn't have property, and that he is prepared to stand in, and if when the time comes to pay the marriage contract, that guy can't pay it, then he, the guarantor, will pay it, despite the fact that normally he's not obligated to. So in other words, they can create that sort of relationship. But absent all that language, no. The assumption is he just wanted to help the groom get married. He wasn't really obligating himself, to be obligated for, 20, 30, 50 years, never knowing when this is going to fall back on his head or possibly even his estate. Now, Rav Huna says that a person on his deathbed, now we're in a new case. Rav Huna says that a person on his deathbed who consecrated all his property to the temple treasury, and then he says, so-and-so has 100 dinars in my possession, meaning I owe 100 dinars to so-and-so. This person on his deathbed is deemed credible, and the money is to be repaid to that person. Now, that's a little surprising, right? If you say, I hereby consecrate, I'm not saying this is just for teaching example, but if a man said, I hereby consecrate all my property as a gift to the temple treasury, right? So now he no longer owns any of his property. All of his property now belongs to the temple treasury. If he says, but 100 dinars of so-and-so is among my property, right? So that part doesn't belong to him. That's why it's not consecrated, and it gets paid back to the one who lent it to him. And that's why he's deemed credible to say, but all that property that I just consecrated, 100 dinars of it isn't mine. It belongs to so-and-so, so that needs to be paid back to him. And this is a person talking on his deathbed. Remember that. Now, the reason for this is that there is a presumption that a person does not collude against the temple treasury. He would not lie about owing money to someone, thereby causing a loss to the temple treasury. Especially on his deathbed, he will soon be standing before the heavenly tribunal. This is not a time to be telling lies. Rav Nachman objects to this ruling. And does a person collude against his children? Of course not. And yet, as Rav and Shmuel both say, that in the case of a person on his deathbed who says, so-and-so has 100 dinars in my possession, meaning I owe 100 dinars to so-and-so, only if he says explicitly, give him the money, then do the children actually give the 100 dinars to that person. But if the one on his deathbed did not explicitly say, give him the money, then the children do not give it. The person on his deathbed is not assumed to be telling the truth about owing the money unless he explicitly instructs that the money be given, right? So they're saying there's a difference between when a person is on his deathbed that so-and-so has 100 dinars in my possession and give 100 dinars to so-and-so. The first statement, we don't take it seriously. The second statement, we do. Meaning the first statement, even so he says, so-and-so has 100 dinars in my possession, maybe he owes it, maybe he doesn't. But if he says to his children while he's on his deathbed, and 100 dinars that I owe so-and-so, give it to him, then we believe him that he owes those 100 dinars. So why do we not believe him in the first case? Apparently then it is assumed that a person is prone to make false statements, even on his deathbed. Why? So as not to make his sons appear sated, i.e. wealthy. What does it mean? A person on his deathbed may falsely claim that he is in debt to someone in order to dispel the notion that his children are wealthy heirs. He's trying to set them up to be a little bit more low profile. It shouldn't be that the town hears that his kids are suddenly rich and now that everyone's going to swoop in and try to take advantage of those kids. So he says, my kids inherit everything that I own, but, I do owe some money to so-and-so and so-and-so. He's just making it up, but he wants people to hear that, well, he owed money. He's not so rich. Now we're on page 175a, getting a head start on tomorrow because we're making a siyum tomorrow, God willing. Here too, with regard to the temple treasury, apply the same principle and say a person is prone to make false statements so as not to make himself appear sated for the same reason. For his kids, well, he's going to leave everything to the temple treasury, but still he doesn't want people to think about him that he's rich. And it is therefore possible that the money was not owed, and payment should not be made from it, should not be made to this person from all his property, which he just consecrated to the temple treasury. And the Gemara answers, when does Rav Huna say that payment should be made there in the case of a person on his deathbed who consecrated all his property? In a case where the creditor to whom the deceased admitted owing money holds a promissory note corroborating the deceased person's admission. And the Gemara comments, well, then by inference, the statement of Rav and Shmuel, where the money is not given to the creditor unless the person on his deathbed explicitly requests that it be given, is applicable in a case where the creditor does not hold a promissory note corroborating the admission. And the Gemara asks, well, if so, how can it be that if the deceased says, give him the money, the children give it to him, i.e., it is collected from the estate left to the heirs, as it is a loan by oral contract. And as Rav and Shmuel both say, one does not collect a loan by oral contract from heirs, nor from purchasers who bought land from the debtor after the loan was granted. So the Gemara has to adjust its answer. Rather, Rav Nachman said, both this case and that case are discussing where the creditor holds a promissory note corroborating the deceased man's admission. And yet, it is not difficult. In this ruling of Rav Huna, the case is where the creditor's promissory note has been ratified by the court. And in that ruling of Rav and Shmuel, the case is where the creditor's promissory note has not been ratified by the court. Therefore, in the latter case, if the person on his deathbed says, give him the money, what he's done is ratify the promissory note. And if he did not say give him the money, well, then he has not ratified the creditor's promissory note. That creditor's going to have to go to court, get the witnesses to come in, ratify the promissory note, and then it can be presented against the estate. But if the guy in his deathbed, agrees with this unratified promissory note, then we would consider it a ratified promissory note. New subject. Rabbah says that in the case of a person on his deathbed who says, so-and-so has 100 dinars in my possession, and the orphans who inherited his property subsequently said, we repaid the debt. Well, they are deemed credible. But if the father said, give 100 dinars to so-and-so as I owe it to him, and subsequently the orphans said, yeah, our father said that and we repaid the money. But then they are not deemed credible. Huh? Why wouldn't we believe the orphans who are saying that our father said, I owe money to so-and-so, give it to him, and then they gave it to him? Why wouldn't we believe the orphans? And the Gemara says, isn't it the opposite? The opposite is more reasonable. If the father says, give 100 dinars to so-and-so, well, since their father has stated the matter assertively, he gave them an explicit directive while on his deathbed, it could be said that the heirs repaid the money. But if the father said, so-and-so has 100 dinars in my possession, since the orphan's father did not state the matter assertively and repay him, it could be said that the heirs did not repay the creditor. We'd have to get more evidence, but we're not going to assume it's true. The Gemara reformulates Rabbah's statement. So, rather, if Rabbah's statement was stated, this is how he stated it. In a case of a person on his deathbed who says, so-and-so has 100 dinars in my possession, and the orphans subsequently said, after his admission, father retracted his words and said to us, actually, I repaid the debt. Well, then we believe the orphans. They are deemed credible. And what is the reason for this? At first, the father had forgotten, but subsequently he remembered paying the debt. But if the father says assertively, give 100 dinars to so-and-so, and the orphans subsequently said that afterward, father retracted his words and said, actually, I repaid the debt, then we don't believe the orphans, not without further investigation. They are not deemed credible. And the reason is that if it is so that the father repaid the debt or was uncertain about the matter, he would not say with such assertiveness, give the money to him. That is evidence that the debt did exist and he probably didn't retract. I'm almost done. Questions or comments, please get them in now. So Rava raises a dilemma with regard to a person on his deathbed who, upon hearing someone's monetary claim against him, admitted owing the money to him. Then what is the law? Is it required for him to say to two people, "You are my witnesses," as is usually necessary in order to prove that an admission is stated in earnest and not in jest? Or is it perhaps not required for him to say, "You are my witnesses," since he is a person on his deathbed whose instructions are generally binding? Second question, is it required that he say to two people, "Write my admission in a document," as is usually required? Or is it not required for him to say, "Write my admission in a document"? And the issue in question here is, does a person sometimes, excuse me, the issue is, does a person sometimes jest at the time of death, i.e., while on his deathbed? Or can it be assumed that a person does not jest at the time of his death, i.e., while on his deathbed? Wonderful question. After Rava raised the dilemma, he then resolved it. And he ruled a person does not jest at the time of death. And therefore, the statements of a person on his deathbed are considered as if they were written in a document and transmitted to the relevant party. They are considered as if they were witnessed, and they needed to be witnessed, but he doesn't have to say officially, "You are my witnesses." We believe that a person on his deathbed is earnest, is serious, and isn't making up stuff. And that concludes our discussion of Mishnah number 9. So tomorrow, God willing, we'll finish page 175, go into page 176 for our discussion of the final Mishnah of chapter 10, which is the final Mishnah of tractate Bava Basra. Bring a l'chaim, and we'll make a l'chaim after we complete the tractate and read the Hadran at the end. Okay, just two questions. One, Bill. One is getting the impression that anytime something seems straightforward in the Talmud, we should immediately get suspicious. Very good. And the Ilanit, I have finished Bava Basra today and attended a couple special study events to celebrate this completion of the 3 gates, Bava Kama, Bava Metzia, and Bava Batra, or some say Bava Basra. It took 411 days. Wow, right? The 3 middle tractates, large tractates known as the gate, right? The beginning gate, the middle gate, and the late gate. This was all about financial transactions in various forms and iterations. 411 of our 2,711 pages are in this. So tomorrow, God willing, we'll all make a siyum together. That's what I've got for us today. And with God's help, see you right here at the siyum tomorrow. Have a great night.